Welcome back to Speak Van Holden 247, etc. And if you like, subscribe and share. We're going to talk about the upcoming November the 22nd hearing in the Delphi murder cases in Indiana. We know that Judge Fran Gull has been appointed to hear the Delphi murder cases dealing with Richard Allen. But what a lot of people don't know, but I want to inform my viewers of something. Judge Fran Gull is on some bullshit too. And I'm finna prove this to you. When she was appointed on this case, she should have counseled the November the 22nd hearing and proceeded with the normal course of criminal proceeding with Richard Allen's attorneys and the DA. Because this is a question of law, and I'm explaining that. But before I do, I want to address the judge. Judge Fran Gull, you have no discretion to determine what the law is when the law is clearly established. You know what I'm talking about. But I will explain it in detail. You also have no discretion in applying the 14th Amendment and the 6th Amendment. You have no discretion. That's clearly established law. Since the facts are already established, we know the only recourse that you can do is order the prosecutor to give the defendant a written notice of the detailed charges. That's the only thing you can do. Now, once Richard Allen was charged and arrested, the 14th Amendment to notice of those charges was triggered among the 6th Amendment. Now, at this point in the game, what do you judge? What do you think that the prosecutor can bring to the table at the hearing on November the 22nd, 2022, to annihilate Richard Allen's 14th and 6th Amendment right? Nothing. Do you hear me? Nothing. I don't care if they say they still investigating. Let me be clear. Ain't a motherfucking thing they can bring to the table to argue that Richard Allen's 14th Amendment and 6th Amendment right is trumped by the code or procedure or whatever facts that they have. It don't exist. There is no legal case law to support their position, but there is legal, well-established case law to support Richard Allen's right to notice of those charges in detail. And let me be clear. And once those charges are presented, he does not have to answer to those charges unless the prosecutor go get an indictment. And we know he's trying to avoid an indictment because going to get an indictment would bring it to the public, meaning the grand jury of public people. See, they are trying to hide those details. Now, so we clear on that judge. Ain't a goddamn thing they can bring to the table. So you already know what it is. Now, ladies and gentlemen, let me explain something. When you see a case is being handled like this here, with the prosecutor trying to withhold information and trying to justify a violation of a defendant's due process rights, that means that they don't really have a case against this man, in my opinion. They don't have a case. That's how you act when you don't have a case. What they are trying to do, in my opinion, is railroad the man. They are trying to force him to plead guilty because they don't want the facts coming out. But here is what I foresee in my mind. This is my opinion. Like I say, people, I could be wrong. I'm not wrong about what I was saying earlier about the judge, but this is my theory on what I think the prosecutor is going to try to do to Richard Allen with the help of his attorneys. This is just my theory. The prosecutor wants to avoid a jury trial. He wants to avoid a trial altogether. But more importantly, the prosecutor don't want a jury trial and the police don't want a jury trial. And I'm gonna explain this here to you. What they want is to trick Richard Allen in with the aid of his attorneys in answering the charge. See, if Richard Allen's attorney does not push to be indicted, then that's a sign that Richard Allen's attorneys are helping the DA convict him when they don't really have a case against him. I'm just going to be straight up with you. Because, see, if he goes to a grand jury, which consists of public people, they have to make known those charges in detail and what evidence he's basing this on. He ain't got to bring all of them, but some of it. That's what the prosecutor doesn't want. See, if you got a strong case, you run to that grand jury and get an indictment. But if your case is weak and it got holes in it, you will seek to work with the defendant's attorney to get him to plead to the charges. That's what you do. So at this point in the game, for my subscribers, they don't really have a solid case against Richard Allen. So what they are trying to do is keep this information out, because once they let it out, it's going to become crystal clear that they don't have a case against him. And here's another thing they're trying to hide. They're trying to hide the fact that, this is what I believe, that the two teenage girls was raped. They're trying to hide this fact. They probably was sodomized as well. This is why the autopsy reports are still sealed. They don't want this information coming out. They know with a trial, a jury trial especially, it's got to come out. So what they are trying to do is circumvent any of this information getting out. And to do this here, Richard Allen's attorney have to be complacent or conspire with the prosecuting judge to keep it out. In other words, if Richard Allen's attorney try to get him to plead the case rather than go to trial, then they are crossing him out. Because the prosecutor already knows that once this man is charged and arrested, his attorneys can ask for discovery. And that's part of the criminal procedure. That's part of due process. So they can ask for the charging instrument, in and all witness and evidence. This is what they're trying to prevent, an actual criminal proceeding going forth, because the case has holes. In other words, they don't have a case against Richard Allen. See, that's why they're doing this here. The cop, the police, he told one reporter, I can't wait to tell a story. He on some bullshit. I saw right through that. That's why they trying to keep the information from getting out. Because once it get out, it may point somewhere else. So it doesn't matter what the prosecutor contend at the hearing. It's clearly established that the defendant has a right to notice of those charges. And even if the judge say, oh, okay, I'm going to keep the record sealed, you still have to get that information to the defendant and his attorney under disclosure. You have to give it to him. So the fact that they are trying to keep this criminal proceeding from going forward, that's a clear indication they don't want a jury trial whatsoever. They damn sure don't want a public trial. That's the gist of the matter. So without further ado, I'm going to let my subscribers go, and y'all have a nice day.